Schedule A litigation, popular in the Northern District of Illinois, lets IP owners fight online counterfeiting by filing cases in secret. This allows them to freeze Amazon listings and funds without warning, stopping defendants from moving assets or changing products. Most defendants only find out after their bank accounts are frozen and stores shut down, leaving them little choice but to settle. Experts call this the Schedule A Defendants Scheme and say it's being used not just to protect IP but to profit from settlements. They argue it abuses the system and targets Chinese sellers by exploiting legal loopholes. Let's hear what the defendants and their counsel in China have to say.
In recent years, we have found out that many U.S. brands, they initiated TRO against Chinese defendants, and they have already established a chain of industry to earn money out of this kind of litigation. But in recent, maybe in the last 12 months, we have also found that Chinese plaintiffs are becoming more and more in litigation.
Okay, thank you. Now, why is the Northern District of Illinois the appropriate place for this case?
We have also found that the patent is maybe not so appropriately priced because this patent was obtained through a patent house that turns out to have engaged in very problematic filings. As we know, as of October 2nd of 2024, the US PTO, US Patent Authorities, canceled more than 3,000 applications from that firm. So that's because the signatures was fraudulent.
大家好，我是亚马逊的一个卖家，我是柴先生。然后在今年9月底的时候，我们收到了亚马逊一个 TRO， 然后把我们的店铺给封了。那么因为这件事情对我们的影响特别大，造成了我们一个资金的一个冻结。那么不仅是资金的一个冻结，还造成了我们整个店铺其他的所有产品影响到了我们整个的其他所有的产品一个发货，包括售卖。因为这一件事情，它牵扯到了有很多。因为为什么呢？因为它这个 TRO 会影响到我们整个团队对于这个店铺的未来的一个走向。也就是说，我们现在这一个团队为了这一个店铺，现在不知道该干些什么。
In this kind of case, the service by email can be a problematic issue as well. The court in the Northern District of Illinois mostly agree that the plaintiff can serve the papers by email. But if the defendant is a US-based company, they require a formal delivery by courier. And with this kind of service by email, the due date for answer is only 21 days, which is pretty short. If the rules require traditional service through the Hague Convention or otherwise, it would not be possible for them to serve hundreds of defendants in one single case, both because of the cost and efforts required, which means that in this kind of case, it's so easy to initiate a case and very easy and convenient to serve by email.
在9月1号那天突然收到这个 TRO 邮件，我们就感觉特别的惊讶，因为我在想说，这市场上已经从去年就开始已经有卖，但为什么说是这个产品还会受到这个外观专利的侵权呢？然后因为在那之前，我们做这个产品之前，我们那时候也是去从外观专利网，包括是国内还是国外的，都去查了，就是说是通过因为我们卖这个产品它是移动空调套件，所以说我们肯定是收对应的那个这个英语关键词收进去查，但是说怎么查那时候都查不到，导致说他因为后面收到这个专利的时候，我感觉他是说是从21年注册，然后到22年下来，所以说我感觉是那时候查不到，就感觉是令我怎么说吧，反正就是说是让我感觉到很难受，因为这个专利不可能说是因为市场上因为说什么是。你已经有这个产品了，你现在还是突然下了这个专利，所以说让我就感觉到是特别惊讶。